ordained at birth. She is one of Jamell Demons' defense attorneys, and they are in court now battling with the state of Florida for the county there in Fort Lauderdale, Broward County. And is the case going to be dismissed? Is it going to be ready to go by October 23rd? If it's not, would the case be dismissed because the defendant has not waived his right to a speedy trial and the clock is ticking? It's a mess. Let's go back into court now as these hearings continue in the run-up to this second trial.
So October 23rd of this month. So, and I know there's, certain other caveats that have to happen. Counsel have, they have 30 motions that they filed recently. It's a new defense team, new additions to the defense team. And there's a lot of motions that need to get heard. I understand all of that, but we all are under the gun, so to speak, because there's speedy trial. My understanding from the defense, they've made perfectly clear they're not asking for continuance. They want to have the motions heard, and they want to be able to go to trial. That's the way I understand it. So it's really imperative that I know who's handling the case for the state.
I understand, Your Honor. And again, I think, you brought up the defense continuance. We wanted to vote witnesses. They are filing motions. They should be taking a defense continuance in order to be preparing for their case. However, I also have another solution for the court, if the court doesn't mind me giving one, and that would be Judge Fine picked a jury this week on a capital case. He had 250 jurors coming in next Wednesday. They were reserved for it, but they got the jury this week. Those jurors are, in fact, available. So that the court could go ahead, because of the prejudice in the state, in the sense that we now have a new prosecutor on the case. And this prosecutor has to get ready. And in order not to prejudice the victims' families and the state and the people of the state of Florida, you could bring a panel in on Wednesday, swear them, and have them come back later on or after the holiday. And then not be a speedy trial. All of these motions could be set, and depositions could all be set within a reasonable time period between then and the jurors are coming back without any other issues with speed. And they could be heard. With everybody having a chance to be prepared.
Understood, and I don't disagree with anything you said, but that doesn't mean that's the way it's going to happen. It's a distinct possibility, but it's also, assuming that if this defense intends on filing a notice of expiration on, you said the 23rd is the date, is that right?
Yes, unless you want me to go to the 21st.
We're not until the 23rd. We would have to file a notice on the 24th.
So if they intend to file their notice on the 24th, I intend to start the trial. And, no disrespect to defense counsel, these motions and depositions are going to be put to the side, so to speak. We're going to go forward on trial. That's what you want. That's what we'll do. If you want to get the motions and the depositions taken care of beforehand, we're going to go on trial Monday through Friday. I think that's what Ms. Bradley and you all indicated that you wanted to do on it. You wanted to say Fridays for whatever type of work you were doing. And I said okay to that unless there's some change. I'll find out who the new prosecutor is on it. We can talk about it, but my thought is we're going to be on Monday through Thursday, and you can do what you need to do on Fridays.
I think our calculation may be speedy runs earlier than the dates of Thursday.
I think it may be on that Friday.
It might be on the 20th.
Shoot.
I'll take it. I'll take the 20th. I'll take the 20th, Judge.
I think you're right.
So there may be less time.
Great.
In that sense.
Whatever it is, and you'll know and you'll let me know. But the point is, we're up in a time crunch.
And let me ask also before, I appreciate the court at least considering the proposal that I made. And also, I know the court's ruling, and it seems as though that a ruling on Ms. Bradley applies to trial, because that's how the defendant's process was to be violated during trial. Is the court ruling that she could not handle the motions, still not handle the motions themselves?
She should be out of the case now.
Judge, the only other thing I wanted to add, Your Honor, is the state, Crawford, and Your Honor agreed to see these materials in camera.
I didn't report. I didn't agree with that.
Take it under advisement. So if in fact you do decide to do that, let us know. And we just ask if you find that it's something that we can have and it is discoverable, we'd like a copy as soon as that decision would be made. That's all.
Well, they're telling me it's something about an ongoing investigation. It's still pending. So typically, that is not something that would be shared with the defendant. I don't know what it pertains to specifically. I have no knowledge of it, but I mean, if it's something that I don't know.
Sure, and that's why I'm asking is that this began before October of 2022. So if it's still ongoing, you know, if Your Honor notices that there's no activity since October of 22, that maybe there would be more to it than just them categorizing it an ongoing investigation. So that's all I'm suggesting is that it may be discoverable regardless of how they label it.
Thank you. Anything else?
Give me still would help or if the court wanted.
I'll let you know. Again, I don't know if it's something I want to look at because if it's an ongoing pending investigation, it's not something I can really share with the defense. And I don't like that. I never really liked doing that with the candidate. So it's not something you can share in open court. I don't know what my feeling is. So let me think about it. All right. But I need to know about the attorney because I need to know when I can schedule hearings. And there's 13 motions to suppress, and I want to get those resolved. I don't know if the witnesses, I assume they're under subpoena for the trial period now because we're supposed to be starting this week.
Your Honor, the last time you made that comment, Ms. Bradley was here, and she said because the jury selection was going to take so long that the witnesses were not under subpoena.
So if that's the case, I don't know if that's the case or not. I don't remember what Ms. Bradley said, but if that's the case and there's no witnesses under subpoena, how long would it take the state to get witnesses for these motions?
As soon as we know, it won't be long. Who is going to be handling the case? We will advise the defense of the order. And that is why, again, the suggestion of making those jurors that are fine that will certainly help in the situation, certainly prejudice the state in the sense that for a new prosecutor to take over this, it's a double homicide, we're asking for the death penalty, it's a case. That's a lot for a prosecutor that on last minute to be trying to learn and to understand and be able to make an argument on. And that's why I made the suggestion to the court of holding in the panel next week on Wednesday, swearing them in, asking them to come back, and then letting the prosecution have the time to prepare for such a large case and these complicated motions. And it will also give the defense time to do their depositions and file whatever motions they want, new motions they can file.
Thank you. Anything else to discuss at this point?
I do have, so since we're doing scheduling, I did have one motion that's not a motion to eliminate. It was basically, it started off as a motion to compel, which would be my second one, to get the self-map evidence. We did get a new expert, which I listed. My new expert went through the documents and then informed me that all the CDRs that the state has been provided are not what comes from a cellular company. They went even further and pointed out that somebody went into the evidence that's supposed to be direct from the mobile company and put phone numbers, the names, assigned names to phone numbers. So I would ask that that hearing be held as soon as possible because we do have an huge evidence issue that needs to be resolved immediately.
Thank you. Well, I'm not going to get involved in that until I know who the prosecutor is. I need to know who the prosecutor is. So my thought is I'll set a hearing. If you have a decision that's going to be made, you think today or Monday? Yes. All right. So if I put this on the docket for Tuesday, does that work? You'll know who is there, and somebody's going to have an opportunity to discuss. I guess whoever's going to do it is going to discuss with the defense counsel about scheduling these motions and which ones are going to go first and which ones you want to do and which ones you need testimony on and where the witnesses are, whether they're available, and how long they're going to be, because there needs to be some discussion regarding that with the defense counsel.
I have the bulk of the motions. I've written that I will be happy to coordinate in any way I can with the new state attorney.
All right, so are we done? Yes?
And Judge, while we're on the record, I do have 4 USBs that were provided by Ms. Bradley to provide defense, so I just want to do that on the record.
Thank you.
Thank you, Your Honor.
Can I see counsel sidebar, please?
Okay, so let me get this right, Judge Murphy. You want to know who the new prosecutor might be. It's kind of a problem he's created himself because he felt necessary to remove Christine Bradley from the case. And now that problem, as they say, some things kind of roll downhill. And the prosecution is dealing with this because it affects everything. And the timing with that October 23rd dismissal potential deadline looming for failure to have a speedy trial. This is very interesting. Matthew Managino is here with me, and also joining the club here is Catherine Lizardo. Is it Friday? Yes, it is. I know it is because Catherine is here. She's a trial attorney from the Dallas-Fort Worth area. So, Catherine, thank you both for cooling your heels while we let that all play out. Catherine, what is your take on all of this stuff, that's my legal term, all this stuff happening as we try to meet that October 23rd deadline?
It seems that all of this stuff is just procedural and very tedious, but what's fascinating is there is a big constitutional issue, which is, you mentioned, the right for speedy trial. That's one of the things I like about being a lawyer is everything that seems to be mundane is actually has an underwriting of something really big. And here, his constitutional right, by October 23rd, they have to have the trial going or else it'll be dismissed. So it's a very big deal. That's my legal term. So for now, I think for the state, all hands on deck. That's what they need to do to figure out who will be the new prosecutor and to get that prosecutor up to speed as to all of the evidence, including the 30 motions that this defense has filed.
Let me ask you a follow-up, Catherine, and this is, I'm going to open up the law and crime classroom here and talk about what in camera means, because there's some evidence that the court has suggested it may need to look at in camera. So this will be on the final. Explain to us what that means.
Well, in camera, actually, you put me on the spot here. I'm having a blank stare here, Professor. But in camera means that the judge and the witnesses for any of their motions will be there outside the presence of the jury.
Yep, and then the court gets to take a look at it and say, this is relevant, this is not, we're not going to get into this, we are going to get into this. It helps speed up the process in some ways, but it also takes more time because the judge has to do it on his own. Okay, let's take a break here. Maddie, I want to get to you as well. We're going to take a break, we're going to come back. This is the Jamell Demons case that just continues to continue, but it's got to come to trial by the 23rd. We'll be right back.